Lovely. Right. Good morning and welcome to the Environment and Energy Committee and Judiciary Committee. We're having a joint hearing this morning on S-259 and Act relating to climate change cost recovery. And to kick us off, we are going to do a walkthrough of the bill with our legislative counsel, Michael O'Grady.
Good morning, this is Michael O'Grady, legislative counsel. You should have S version of S-259 in front of you or on your iPad. Generally, what S-259 does is it establishes a program at the Agency of Natural Resources to recover from responsible parties costs to Vermont of covered greenhouse gas emissions that they have made on climate and associated damages to Vermont from climate change. The damages that are sought are from a covered period from January 1995 to December 2024. The payments that the responsible parties make to the state are deposited into a special fund. It's then used to pay for climate change adaptation projects and similar other projects to address the effects of climate change on Vermont. So that's generally what the bill does. Beginning on page 1, line 4, section 1, there's a title. The act is cited as the Climate Superfund Act. Then you go to page 1, line 6, there's a new chapter of law being added to Title 10, the Conservation and Development title. It is called the Climate Superfund Cost Recovery Program. First section, section 596, it's the definition section. Important definition is on line 11, climate change adaptation project. Project designed to respond to, avoid, moderate, repair, or adapt to negative impacts caused by climate change and to assist human and natural communities, households, and businesses in preparing for future climate change driven disruptions. There is then a list of what those projects include. I won't read through all of them, but it includes things like preventative healthcare programs, providing medical care to treat illnesses caused by the effects of climate change, relocation, the elevation of infrastructure. Next page, page 2, it also includes weatherization and energy efficiency upgrades and payments for crop loss. Moving out of that definition on page 2, you can move to, I just want to reference on line 12, page 2, line 12. There's a definition of controlled group. This is an Internal Revenue Service definition related to when you treat a group of corporations as one so that the corporations don't avoid their tax penalties. You're going to treat those groups of corporations operating as one the same way here so they don't avoid their potential damages liability under this program. Moving on to page 3, definition, cost recovery demand. It's a charge asserted against the responsible party for cost recovery payments under the program for payment to the fund. Greenhouse gases or covered greenhouse gas emissions. It's the total quantity of greenhouse gases released during the covered period, expressed in metric tons of carbon dioxide equivalent resulting from the use of fossil fuels extracted or refined by. You see what the cover period is directly below that. It's January 1, 1995 to December 31st, 2024. There's a this definition of oil is fairly intuitive. And then there's the definition of entity. These are the persons, the corporations, companies that will be ultimately the universe of responsible parties. So they're individuals, trustees, agents, partnerships, associations, etc. Pretty much every type of legal entity you can think of that holds or held an ownership interest in fossil fuel business during the covered period. Environmental justice focused population is the same as what is in Title 3, which I believe at least the Environment and Energy Committee is aware of. Fossil fuels, coal, petroleum products, and fuel gases. Fuel business is engaging in the extraction of fossil fuels or the refining of petroleum products. Going on to page 4, You can probably skip down to line 10. What is a nature-based solution? It's a project that utilizes or mimics nature or natural processes and functions and may also offer environmental, economic, and social benefits by increasing resilience. That is a key part of the climate change adaptation projects and what would be allowed underneath those projects, and that's why it's defined. Page 4, line 17, petroleum product, any product refined or re-refined from synthetic or crude oil extract natural gas liquids or other sources of industrial into crude oil. On page 5, a qualifying expenditure, an authorized payment from the fund, pay reasonable expenses associated with the administration of the fund and the programs, and as part of the support of the climate change adaptation project, including its operation, monitoring, and maintenance. I will say that reading this over and talking to some of the parties, I think this language needs a slight change because it can read as expenses associated with the administration of the fund and the program, and as a part of the support of climate change. It really is to pay for the support of a climate change adaptation project, not as part of. And I think that could be clarified for purposes of what is a qualifying expenditure. Then you get to page 5, line 5, who is a responsible party? Remember, there's that every legal entity or type of legal entity that you can think of that held an ownership interest in one of these companies or their successor in interest that during any part of the covered period, 1995, 2024, was engaged in the trade of business of extracting fossil fuel or refining crude oil. So that's the limit. They're extracting fossil fuel, refining crude oil. It's determined by A&R, be attributable to for more than 1 billion metric tons of covered greenhouse gas emissions during the covered period. The term responsible party does not include any person who lacks sufficient connection with the state to satisfy the nexus requirements of the U.S. Constitution. That means that if they are not availing themselves of the jurisdiction of Vermont through the sale of their products, through the distribution of their products, the use of their products in the state, they are not subject to the regulation by the state. That is just a core principle of state regulatory authority. And strategy, you will see later on in the bill, is the resilience implementation strategy adopted by the agency to address those projects or activities that the state can conduct to address climate change and climate change resiliency. We'll get to that in a few pages. Then on page 5, line 14, section 597, you get to the establishment of the program. It's established at the agency in the Office of Climate Action Office. It shall be established for the following purposes: to secure compensatory payments from responsible parties based on a standard of strict liability, provide a source of revenue for climate change adaptation projects in the state, to determine proportional liability of the responsible party, to impose cost recovery demands on responsible parties, and issue notice of cost recovery, to accept and collect payments from responsible parties, develop, adopt, implement, and update strategy that will identify and prioritize climate change adaptation projects, and corresponds to implement climate change adaptation projects identified in the strategy. Before I move on, I want to ask and emphasize the fact that this is a strict liability standard. Does everyone understand what strict liability means?
It could be great for you to tell us.
So strict liability is a legal standard where it holds a person liable for damages or other financial responsibilities for who they are or what they have done, regardless of whether the party was at fault, had any intent to engage in that activity or damages, or was negligent. So it's really about who you are, potentially what you did, regardless of your fault, regardless of your intent, regardless of whether you were negligent.
Oh, yeah.
Just for context, can you share what other terms would be instead of strict liability standard?
Sure, negligence would be one if they were negligent, if they intentionally or knowingly.
Okay.
But
It's in
here,
that.
there is no mens rea. It's whether you are liable because who you were or what you did.
Yeah, Representative Rachelson.
Can you give an example of another type of business that we hold to strict liability?
Sure, so and it's very similar to this program. This bill is called the Climate Superfund Act. And there is a program called Superfund or CERCLA or State Superfund. And that holds the owner of a facility, the operator of a facility, a transporter of a hazardous material to a facility, or a ranger for the transport of that material to a facility strictly liable for the release of a hazardous material from that facility. Regardless of whether they negligently released it, whether they intentionally released it, or knowingly, whether they knew what they were transporting was a hazardous material, they are strictly liable because they were somehow responsible for that hazardous material being at that facility and for being released. Period.
Representative Ghostland.
So it makes it sound like this is like dealing with asbestos or something like that, which I'm not even sure when asbestos came out that people knew how bad it was. But we're primarily talking about big oil, right? That's what all the signs are around the State House at different times and things.
You're talking about fossil fuel companies.
Yeah.
And those that were distributing, selling, authorizing the use of their products in the state, yes.
Yeah. So just like asbestos years ago, you weren't forced to use it. The big thing is you didn't know about it, right? I'm gonna focus on big oil. Nobody forced you to use any big oil product at all. You're not forced to use it. You chose to use it. So my question is, you want to go after big oil? You want to go after all this other stuff? What's stopping big oil from suing Vermont?
Well, let's be clear. I think that there will be litigation that arises from enactment of this act because it would be a first in the country act and it would be imposing significant liability for the damages caused by the emissions of those fossil fuels. So nothing would stop them from suing Vermont, and I expect that they will.
And as I understand it, I'm not an expert, but maybe a little common sense, but a lot of our emissions are caused because we're recreation sake. People come to Vermont, and that adds to it. The same as all the great stuff that happened on Monday, which was a absolute sensational day. Not everybody came here in an electric car or anything like that, and they flew in here with their airplanes and all this other stuff. And I'm sure our emissions went up greatly that day. But we're a state that prides itself. We need recreation, and it worked, and I'm thankful for that day.
So remember how I said that Superfund is a similar program, CERCLA, the hazardous materials release. So courts have looked at some of these arguments similar to looked at these arguments under CERCLA that are similar to what the arguments may be in this case. And one of the things that happened with CERCLA is that it applied retroactively as this bill does, because it's bill applies to that cover period 1995 to 2024. CERCLA reaches back far beyond that. Goes back to World War II and maybe even beyond in its retroactivity. And the things that it imposed the liability on were legal at the time that they were conducted. And the courts have said, even though that it was legal, it was certainly foreseeable at the time that the improper disposal of material, hazardous material, could lead to liability. And it was certainly foreseeable, which you're going to hear testimony about from advocates, that these fossil fuel companies knew that the use of their products was going to create environmental impacts and or damages. So that is the policy basis that you're going forward with, is that, yes, it may have been legal. Yes, it may have been a choice, but it was reasonably foreseeable at the time that these products were manufactured, sold, and distributed into the state, that the manufacturers knew that they were going to create environmental damage.
Thank you.
So moving on from there, page 6, line 8, you get to the liability of the remaining parties. Again, the responsible party shall be strictly liable for a share of the cost of climate change adaptation projects and all qualifying expenditures. There's that definition of both of those terms in the definition section. For purposes of the section, entities in a control group, remember, I just pointed out that Internal Revenue Service definition. You're going to treat those control group companies the same as one entity, and they can't escape liability. They're going to be held to the same standard of liability. And then on page 6, line 17, with respect to each responsible party, the cost recovery demand shall be equal to an amount that bears the same ratio to the cost to the state of Vermont and its residents. It's calculated by the state treasurer pursuant to section 5999C from the emission of covered greenhouse gases during the covered period as the responsible party's applicable share. Covered greenhouse gas emissions bear to the aggregate applicable shares of covered greenhouse gas emissions resulting from the use of fossil fuels extracted or refined during the covered period. That's a lot of legalese, but it's an important section. First, one of the important parts of this section is it's referencing the state treasurer's report. The state treasurer, which you will see later on, is going to submit to you a report analyzing the cost to Vermont of the emission of covered greenhouse gases during the covered period. So you have a baseline cost to review. And that then is the manufacturer of the fossil fuel business, the responsible party. They pay a cost that is the same ratio to the damages. Let me step back. Let's just try to simplify it. What ratio they had to the contribution of greenhouse gases is the same ratio that they will have to payment for the cost to Vermont. And so that is the way to simplify this language. They had 10% of the greenhouse gases during the covered period. They paid 10% of the cost to Vermont from those greenhouse gases.
Representative Smith.
Thank you. So what you're saying is that any billing or anything that the state of Vermont might have to pay is expected to be paid for by fossil fuel companies in litigation?
Any billing? I'm not sure what you mean.
All the costs to the state of Vermont hopefully will be covered under any court settlements by the fossil fuel companies.
So no, this isn't about paying the cost of litigation. There will be costs of litigation, and you can talk to the Attorney General about that. That is not, this is about paying from the fund for qualifying expenditures and climate change adaptation projects. So things to remedy the damages caused by covered greenhouse gases and the climate change damages from those. This is not about getting money to pay for litigation. There's going to be litigation. The state's going to have to pay for it.
What would be for example, to pay for the cost, like what?
So go back to the first page of the bill and that definition of climate change adaptation project. And what could be paid for from the fund are projects such as as upgrading stormwater drainage systems, making defensive upgrades to transportation infrastructure, raising wastewater treatment plants so they don't flood out because they're often in proximity to waters. And so that type of project, which is directly connected to the effects of climate change.
Okay, one last question for that. Could one assume that S-259 is gonna have the potential to shut down all the fossil fuel dealers and many of the gasoline stations and service centers around the state of Vermont in time?
I don't think that's likely to happen. First, this isn't imposing on the gasoline dealer the liability of the gas station. It's imposing on the extractor or of the fossil fuel or the refiner of the petroleum product. So it's further down the chain. Those are the companies that are supplying the products into the state for their sale distribution. It's not the home heating oil company. It is not the gas station that is subject to the liability.
However, their prices will go up eventually and inevitably.
Yeah, I mean, yes, maybe, who knows? No, like, I think all of those answers are rational answers to that question, because it's a gasoline and heating fuel, they're regional markets, right? The product is sold from a rack, in Springfield or elsewhere, and it's distributed all across New England. Will the price be different if the product is ultimately going to land in Vermont? I don't know, and I don't know how they would do that.
Yeah, thanks.
Representative Sibilia.
Michael, did the Senate take any testimony on the relationship between the extractors, the refiners, and the suppliers?
No, they didn't take any testimony, but I did my research on that. I tried to find, but what I tried to find was I tried to find a gasoline station that wasn't affiliated with a refiner of petroleum. And I could only find one, and it was in the Northeast Kingdom at some little country, town store. Everybody else is affiliated. Everyone else has a franchise agreement. Everyone else has a supply agreement. They're all affiliated with a refiner.
They're all affiliated, so there's each,
They all have a supply contract or a franchise agreement with a refiner.
with the refiner. So I just don't know enough about the industry. So
So
is the extractor and the refiner and the supplier often the same company? That's, I guess, my,
the refine, you're talking for gasoline, you're talking about refiners, the petroleum product refiner, and they can be the same company, but they can use a distribution network as well. And that is okay, because the courts have said when a manufacturer avails himself of or herself of the jurisdiction by the use of a distribution network that is intended to interject that product into the state, then the state has regulatory jurisdiction over that manufacturer. Think of what the Supreme Court recently did with internet taxation and Wayfair and all of that you can still tax those sales, even though, Wayfair is located wherever they are, Arkansas. And never avail themselves, never actually have a physical presence in the state. They've availed themselves of the state by shipping and advertising and doing everything that they do in order to sell their products.
it's less a jurisdiction question in my mind that I'm having so much as a who's who and who are we going to be having?
And I do want to focus, it is on the extractor, the entity holding ownership of the company that removed that fossil fuel from the ground or that refined that crude oil or petroleum product. Those are who you're talking about.
Right.
You're not talking about the home heating fuel company that went down to the wreck at Springfield, filled up a few trucks and trucked them back.
So how do we track? I'm sure we're gonna get into this. Do you understand my question?
I do, and come to my attention that our next witness has a pretty hard time constraint, and so I'm actually gonna ask our members to hold questions. We'll have time for questions and ask our legislative counsel if there are any other really important parts for us to understand before we just put a pause on the walkthrough and shift to Professor Mencken.
Sure, that's fine. I mean, there are other things you should look at, but you're more than welcome to wait.
Okay, nothing else that we need to understand before we, okay, thank you. Sorry for the interruption. And questions are great, but we have a time constraint. Welcome, Professor Mencken.
Thank you. Can everyone hear me all right?
Yeah.
Great. And I appreciate the accommodation. I have to go give back-to-back lectures to my students here at Dartmouth, and the first one begins at 10:10 a.m. So I would just want to make sure that everyone can see my slides okay and that you can see them in advance. Is that right?
We can, yes.
Excellent. All right. Well, barring anything else, I'll just go ahead and get started. Morning to you all. My name is Justin Mankin. I'm a tenured professor of geography at Dartmouth and a research scientist at the Division of Ocean and Climate Physics at Lamont Doherty Earth Observatory of Columbia University. At Dartmouth, I direct the Climate Modeling and Impacts Group, where we work to understand the impacts of human-caused global warming on our water, our food, our recreation, our infrastructure, and our economic and physical security. Much of our scientific research centers on using observations and models to quantify the impacts and costs of global warming to date and to estimate how those impacts and costs may evolve in the future. Our goal is to improve our understanding of the consequences of warming for people and the things they value, and to inform the difficult decisions that those consequences will compel. My climate attribution work and that of my group has been published in leading peer-reviewed scientific journals like Science, Nature, and the Proceedings of the National Academy of Sciences. I hold an undergraduate degree and Masters of Public Administration from Columbia University, a Master of Science from the London School of Economics, and a PhD in Climate Science from Stanford University. I'm here to provide testimony on S259, an act relating to climate change cost recovery. I hope you will take away the following 4 key points from my testimony. Firstly, using peer-reviewed consensus scientific methods, scientists can quantify the economic losses a region like Vermont has endured from the impacts of global warming to date. Secondly, using peer-reviewed consensus scientific methods, scientists can attribute those losses back to particular emissions or emitters. Thirdly, using peer-reviewed consensus scientific methods, scientists can estimate the net present value of future damages associated with both historical and future emissions. Lastly, it is my opinion that we are systematically underestimating the economic costs of climate change to date, and that is because all of these climate damage cost accounting methods are inherently conservative or limited by data. Losses from climate change abound, but who pays and how much? And these are questions that are ultimately being resolved in courts and legislative bodies such as this. Science can help provide answers to these questions. In particular, science can help by quantifying the damages and attributing them back to particular parties. In general, there are 3 sets of costs to consider in assessing total damage due to climate change, and there are different methods to estimate each of these. The first is the cost of the damage promulgated by historical emissions. So these are the costs that have already manifested in Vermont's economy owing to the hazards from human-caused global warming to date, like floods. The second set of costs to consider are those costs that will arise from future hazards which have their origins in historical emissions. The effects of carbon dioxide or CO2 are cumulative and CO2 has a very long residence time in our atmosphere, such that some fraction of the first ton emitted at the dawn of the Industrial Revolution is still up there warming our climate system and generating impacts. This means that emissions already released from fossil fuel combustion and to that which we can attribute historical climate damages in places like Vermont, that will continue to cause Vermont damage into the future. And the last cost to consider is the cost from future emissions. Decarbonizing our economy will take time and in itself will be energy intensive. And to the extent that that decarbonization is reliant on fossil fuels, future emissions will generate future impacts and those impacts costs. Thanks to the very careful work of researchers like Rick Heady, who will be testifying later this morning, we have time-varying Scope 1 and Scope 3 emissions data from major fossil fuel firms that position the apportioning of any one of the aforementioned costs back to particular emitters. Now, there are a number of scientifically defensible and rational approaches to calculating the costs attributable to each of these terms and then apportioning them back to particular actors or emitters. But I would generally classify damage attribution work into two approaches. And I emphasize that both of these approaches have a rational basis, which implies that the Treasurer and the Secretary of Natural Resources would have options in how best to approach any accounting. Now, the first approach relies on using some estimate of the marginal damage to Vermont from a ton of emissions, like that embodied in the social cost of carbon, or SCC. The SCC is a dollar estimate of the discounted welfare costs associated with emitting 1 additional ton of carbon dioxide into the atmosphere. Right now, using various methodologies, the Environmental Protection Agency places the SCC at $190 per ton. And with that legally binding estimate in hand, one could apportion economic damages attributable to particular emitters or emissions based on a chosen covered period. There are undoubtedly nuances there, and I would direct your questions on that approach to Rick Heady, who is testifying later this morning. A second approach is one that my research team, among others, has been working on, which we call end-to-end attribution. Our approach isolates and quantifies particular climate damages attributable to particular emitters, and owing to the modularity and flexibility of the framework, it can be applied to myriad contexts, from single events to cumulative harms, from emitters of individual firms to nations, and it can consider different climate change-driven hazards, from changes in average temperature to heat waves to storms, droughts, floods, among others, given data availability. Our framework uses consensus peer-reviewed methods and resolves nonlinearities in the relationship between greenhouse gas emissions, atmospheric concentrations, temperature changes, physical hazards, and consequent damage. And our rigorous treatment of causation in this methodology is designed to meet scientific and legal standards, resolving uncertainties major carbon polluters have hidden behind for decades. Climate attribution science is an extremely well-established consensus science, informing synthesis reports like the Intergovernmental Panel on Climate Change and the National Climate Assessment, and it's been used to establish causal links between global warming and various hazards like floods, droughts, heat waves, snow loss, tropical cyclones, and other hazards. Similarly, there is considerable peer-reviewed consensus work that documents and attributes the monetary losses from climate impacts, so-called climate damage assessments. Now, these damage assessments are often grounded in empirical or semi-empirical models called damage functions, and these connect climate-related extremes like a heat wave or a flood to some kind of policy legible outcome like lives or income lost. And with these damage estimates, decision makers can better understand the costs of climate inaction and weigh them against the net benefits of adaptation and mitigation. Now, these attribution methods all share a similar framework, which I'm showing you here in this slide. Essentially, they are comparing outcomes in two groups, just as you would in a medical drug trial. In a drug trial, participants are randomly assigned into a treatment and control group. The individuals in the treatment group, here represented by the orange bars, receive the drug, and those in the control group shown here by the blue bars, do not, and the medical outcomes among the two groups are compared. And here we can see that even though some individuals respond differently, we can make an attribution of the efficacy of the drug treatment. It is the difference between these two distributions. Some deleterious medical outcome, in this case, is reduced from the drug, denoted by the lower values of the treatment group. We can extend this toy example to climate attribution in general. We compare outcomes in a world with versus without climate change. The distinction here is that we use models rather than a randomized control trial to construct the control group or the counterfactual world without particular emissions or climate change. I'm happy to delve into the mechanics of the approach if the committee have questions. I also include 3 scientific manuscripts with my testimony today, as well as one from another research group documenting our approach. Briefly, our approach is to use an integrated modeling framework built on consensus peer-reviewed methods that allows us to build a transparent and reproducible chain of causality from emissions all the way to damages, where we're resolving the ranges of outcomes at each step in this causal chain that you see here on this slide. And we do this by simulating the emissions to damage, leaving out one particular emitter at a time, or one particular set of emissions, effectively creating a control group. And then we're just comparing 2 worlds, just like in that medical trial. One that includes the world as it has been with climate change, and one where the emissions of one group of emitters has been removed. And the difference between those 2 worlds, that is our damage assessment. We have applied this framework to assess income loss due to historical emissions driven changes in average temperature, and we've also applied it to heat waves. I note that this can be extended to other hazards like floods or drought, and to other damages like mortality or morbidity, depending on the use case. What we know from these individual damage assessments is that the costs of climate change to date are far higher than previously understood. And we have shown that for average temperatures, for extreme heat, and for climate variations that could be affected by climate change like El Nino. Because these costs attributable to these individual hazards are so large, and they focus on quantities that it is easily measured, it is my assessment that any accounting for the damages to date are a systematic undercounting and are therefore inherently conservative. Thanks for the opportunity to speak with you today, and I'll stand by for your questions.
Thank you for your testimony. Representative Sibilia has a question.
Yes, thanks for your testimony. Can we go back a slide? And can you just walk me through this kind of in layperson language for my 6th grader? Maybe not my 6th grader, but my senior in high school.
I would be happy to. What I'm showing you here is what I think are the linkages that connect particular emissions to particular harms. And the development of this has been in the liability rather than in the purely loss and damage context, which is why I think the Treasurer and the Secretary of Natural Resources has actually a number of options here. But essentially what I'm showing you here are the steps in our modeling framework. And essentially we have a situation where carbon is emitted to our atmosphere, but not all of that carbon that's emitted is doing warming that causes damages. Some fraction of that carbon is taken up by the land surface, some fraction of that is taken up by the ocean, and that is part of the natural carbon cycle, the cycling of biogeochemistry in our Earth system. And so there are a range of carbon concentrations consistent with any 1 gigaton of emissions, and our modeling framework explicitly resolves that. Once you have a sense of what the changing atmospheric greenhouse gas concentrations are given a gigaton of emissions, right, that is the thing that is altering the radiative balance that warms our planet. You can think of it akin to hair clogging up your drain in your bathroom sink. It is harder for that water to leave that sink, and it is harder for energy to leave Earth, and that's what's causing the warming. So the next stage is translating those concentration changes of greenhouse gases or carbon into global temperature changes. And our modeling framework does that as well. So we're doing this each time, we're doing it many, many times, where we're simulating the world as it has been with all emitters included, and then we're doing it again, removing one emitter at a time. So one carbon major or one nation or what have you. And so we have a set of global temperature changes associated with those atmospheric carbon concentration changes. There are a number, owing to feedbacks in the Earth system, a number of global temperature changes consistent with any one change in carbon concentrations. And so again, we are resolving those uncertainties at this modeling step. Then those global temperature changes manifest locally differently. And so the next stage of the analysis translates those global temperature changes into local temperature changes, say for a region like Vermont. And what we are doing there is deconvolving year-to-year variations in the climate system. Some years are warmer than average, some years are cooler than average. And our approach explicitly samples that uncertainty to get a sense of how different local temperatures would have been in Vermont absent the emissions from a particular actor. And then the last step of the analysis translates those climate hazards. Here we're thinking about local temperature change, but one could imagine using floods or droughts or other contexts. And what we're doing then is applying that damage function that I discussed earlier in my testimony, which translates the hazard itself, the climate hazard, whether that's a drought, a flood, or a heat wave, into some kind of socioeconomic outcome. Here, what we've done in our work is looked at income lost. So what is the growth economically that would have occurred absent these emissions? And how is that different from the growth we have actually seen economically? And that difference between those two worlds, that is a measure of the income difference traceable back to the emissions and how those emissions have generated hazards. And so that's the damage assessment portion. And the power of this framework is that it can be applied at many different spatial scales, over many different temporal scales. It is incredibly flexible in that we can consider different sets of emissions or emitters, and it's kind of scale agnostic in that sense. And it can be applied over myriad time periods, right? Such as if Vermont's covered emissions time period is different from another state that's also pursuing similar legislation, this method is highly modular and flexible and can accommodate that. And it can also accommodate the fact that maybe heat waves haven't been particularly damaging to Vermont, but floods have been. And so maybe that's the hazard of choice here. Or maybe Vermont just wants to consider a more abstract aggregate measure of climate damages, such as mean temperature change. And my colleagues at Stanford University, Dr. Marshall Burke and others, have pioneered a method looking at that. So this is our modeling framework, and it means that there are a number of approaches that have a rational basis for getting a sense of what these damages are and then apportioning them back to particular emitters.
Great, thank you. I was challenged on the range, understanding the range. So that was really helpful. Appreciate it.
Representative Lalonde and then Dolan.
So,
And Rachel.
with respect to flooding, I'm just curious, maybe you can provide more concrete example for us. This past summer, we had significant flooding. How would that, any damages resulting from that flooding be apportioned to particular emitters?
Sure. In our framework, I think there are a number of ways to do this, right? There's an approach that essentially says, well, how much additional damage occurred owing to climate change, right? And what is that magnitude? So there would be an attribution involved there. And then you could just apportion that based on the ratio as laid out in the bill, because we know how emissions have translated via the attribution. We know how emissions have translated into changes in the magnitude of the harm. in my approach, which is a different approach that kind of moves on a hazard by hazard basis, essentially what we would do is and these already exist, there are damage functions for floods. So we have a sense of what the economic consequences generally are for floods. And we can apply that general relationship between income loss and a flooding event of a particular magnitude. We can apply that to the context of Vermont. And essentially, this framework positions us to re-simulate that event from last summer, absent the contributions of particular emitters, and compare how damages would have been different under reduced emissions if one emitter had better mitigated their emissions, essentially. And that's the apportioning exercise in my framework. And I just want to emphasize that this is but one approach.
Thank you.
Representative Dolan.
Yes, thank you for this overview. I feel like I understand it at a very high level and appreciate it. I think you may have answered this as well regarding date limitations to it. Curious if there are factors in this that there are date limitations to, or that this can go for any time period. Because for us in this bill, we're looking specifically at January 1995 to December of this year. Like, can you go before that? Are there any date limitations that we should be considering with this data process?
Yeah, the representative raises a really essential point here, which is, I would argue, generally the province of policy and law and not of science. But I think what you're pointing to is, what are the data limitations in our ability to do this accounting over particular time periods? And certainly data limitations are a real issue in doing damage assessments in general, which is another reason I think all of these cost accounting methods are inherently conservative. There are a number of missing costs of climate change that we cannot calculate owing to a lack of data. And I don't know if anyone is a baseball fan, but 2 years ago, or last year actually, my research group, we published a manuscript where we were actually able to attribute the additional home runs in Major League Baseball due to global warming that has occurred. And we were able to do this at the ballpark level, which is kind of a remarkable, but also totally innocuous impact of global warming. The reason we were able to do that work is because Major League Baseball is self-obsessed in $1 billion industry that has high-speed cameras in every ballpark around the country, allowing us to estimate the launch angle and launch velocity of every batted ball, such that we could compare the distance a batted ball flew on a warm versus a cool day. So that data positioned us to perform an attribution that no one would have ever thought of necessarily. And it makes me wonder what other damages we're missing owing to a lack of data. And so I think that's a really important thing. Rick Heady from Climate Accountability Institute, who will be testifying later, has done heroic work pulling together time-varying emissions data from major fossil fuel companies associated with their production. And so those data exist for the covered period, and certainly for before as well. But the choice of when you start to do the damage accounting and the choice of what constitutes the covered period, those are policy choices. And certainly we could go back further. And in our work on heat waves, we go back and we consider to 1920. We also go back and consider to 1850. But when is it appropriate to start accounting for damages? And I would argue that those are policy questions, right? One can benchmark the appropriate time point for accounting for damages back to, say, the mid-1970s, when ExxonMobil's own climate scientists, via internal reports, knew of the warming consequences of their business model. And if, rather than taking steps and taking some of their revenue to invest in mitigation measures, instead, what they did is took their revenue and invested in a mass disinformation campaign that has led to a massive amount of climate skepticism in popular culture and has put us on this trajectory. And so that that question of when do you start is one for policy. One could also imagine beginning it in 1990 associated with the kind of the international consensus around global warming being a harm scientifically. So there's a number of different there's an interaction there between kind of the choices of policy and the data limitations, but absolutely we can go back further.
Thank you.
All right, do you have time for one more question? I know you need to be done in about 2 minutes.
Yes.
All right, Representative Rachelson.
Thank you. So one question that I'm wondering about is how, when you talk about the range in the relationship between warming and the damage and what things would have looked like, how do you account for other possible variables that might have factored in to sort of what you're comparing the perfect, like if we didn't have climate change? So if a war had broken out and there had been loss of production or some other variable.
Yes. So if I understand the question correctly, the representative is asking about the creation of this counterfactual world absent one emitter, right? So we've
Yes.
essentially tried to re-simulate the world as it could have been without a particular set of emissions. And we are not, to be explicit, we are climate physicists. We are simulating the physical response of the climate system, and then leveraging empirical relationships between like the physics of the climate system and socioeconomic outcomes that we know to be generally true given observations. And so we are not simulating, for example, how markets would have been different if one emitter was removed, or what socioeconomic and demographic changes would have occurred if one emitter was removed, or how that would have altered policy outcomes. The world we are imagining here is a very simple one. It's one where a particular emitter recognized the harms associated with their business model and internalized that externality through mitigation. And so we are not simulating any of those other complicated dynamics. It is simply a but-for attribution. But for the contributions of this particular emitter, the world would have been thus. And in all of these cases, what we show is that the veil of plausible deniability is pretty threadbare, right? The claim around climate change is that we are all emitting, that we are all culpable, and that therefore there need not be some kind of restitution or reckoning associated with that. But the fact of the matter is we can detect the harm associated with one emitter, and we can do that very conclusively given very strict scientific standards. And that means that we can equally detect the benefits of one emitter reducing their emissions or ceasing their emissions altogether.
Thank you.
Thank you so much for your testimony and for adding another lecture to your day.
Yeah, thank you very much. And I would encourage anyone from the committee to reach out to me if I can be helpful in your deliberations. Thank you for your work.
Thanks. Members, I think what we'll do is hear from one more witness and then take a break. We'll welcome Rick Heedy. You joining us.
We don't yet have Rick Heedy on the call.
Okay.
We are expecting this one or two.
What's up?
Take a break.
All right. We'll take a